Welcome to this clip on the interaction between EU courts and national courts of the EU member states. After watching this video, you will be able to describe the different ways in which a national court can seek the assistance of the European Court of Justice when dealing with state aid cases. We will discuss the preliminary procedure allowing national courts to refer certain matters to the Court of Justice for a preliminary ruling. Article 267 TFEU forms the legal basis allowing national courts to ask the European Court of Justice through a preliminary reference to rule on the validity of EU acts on the one hand and on the interpretation of EU law on the other. Although national courts cannot rule themselves on the validity of EU acts, they can request the European Court of Justice to clarify in a preliminary ruling whether an EU act is valid or not. For example, a party may raise the invalidity of a Commission recovery decision in the context of national proceedings following a request from the state to the beneficiary of unlawful state aid to repay this aid. To consider whether it's mandatory for the national court to refer for a preliminary ruling, we need to look at the position of the court concerned in the national procedural framework. A national court that does not rule at last instance can conduct an initial examination of the validity of an EU act and decide that that act is valid. In that case, the court does not have to submit a request for a preliminary ruling to the Court of Justice. However, if the court is of the opinion that the EU act is probably invalid, it must refer the validity question to the European Court of Justice, which will then decide whether the act is valid. However, national courts that rule in final instance are in principle always obliged to ask the European Court of Justice to clarify the validity of an EU act when a party raises the alleged invalidity. However, if the validity question raised before a national court is not relevant for the proceeding, the court concerned is not required to refer the question to the European Court of Justice. If national courts that do not rule at last instance have a question about the interpretation of EU state aid law, they can request the Court of Justice to answer it. There is a presumption of relevance for preliminary references from national courts. However, the European Court of Justice will not reply to references that do not relate to a real dispute or the subject matter of the dispute, to hypothetical questions, or to questions in which the Court of Justice does not receive sufficient factual or legal information to provide a meaningful answer to the preliminary question raised. National courts that rule at last instance, however, must refer their questions about an interpretation of EU law to the Court of Justice. This clip provided an overview of the interaction between EU courts and national courts. We explored the legal system enabling national courts of EU member states to submit specific issues to the Court of Justice. There are two avenues through which the Court of Justice can engage. Firstly, to provide a preliminary ruling on the validity of an EU act, and secondly, to offer clarity on queries related to the interpretation of EU state aid law. This brings us to the end of the clip on the enforcement of EU state aid law by national courts. Thank you for your interest and attention.